Welcome to the University of Ottawa, Canada's university.
Understanding all this stuff about double.
So we'll continue with the panel this morning, but before introducing the subject of the panel, I just want to mention in the schedule you'll notice that you got in your package, so there'll be a break at 11 o'clock.
I know it's not.
And then at 11:10 we'll be breaking into academic roundtable discussions. In your, again, in your conference package, when you open it up, you'll see there's a room number on a tag inside the, and that's the room that you're assigned to. The problem is we think we only have enough people for 4 rooms, and we booked 5. So there's some people that will have FTX 316. And so we'll ask those people to go to FTX 315 instead of 316. And in each group, so we'll appoint that there will be 4 of us presiding the groups or facilitating, and then each group will appoint a rapporteur, and then we'll try to bring out 1 or 2 key issues from those meetings, and then report back to the committee of the whole after. Is that any questions? Is that all clear? That clear as mud? Then we'll get on with the first and only panel today. The contemporary Métis Crown relations and Métis rights issues, to be chaired by Yvonne Boyer.
Thank you, Darren. I would just like to mention that I am a Métis from Saskatchewan, and I'm the granddaughter of Mary Rosalie Larocque and Louis Amab Boyer. And they hail from the Red River, and they came from Leroy, North Dakota. So I'm really pleased today to be your chair for this esteemed panel on the Daniels case. And we know that the Daniels case is about Métis and non-status Indians being included in federal jurisdiction under Section 9124. I must say the timing for this conference is impeccable because we are now awaiting the Supreme Court decision. And today we have 3 experts to tell us all about it, and they will be presenting various aspects of the case. Our first presenter is Professor Joe Magnet, who is a law professor at the University of Ottawa. He's an accomplished lawyer and he's an author, and notably the General Counsel to the Congress of Aboriginal People. And we are really lucky to have somebody speaking to us this day that's this knowledgeable about the intricacies of the case. Professor Magnet will be speaking about various aspects of the Daniels case. The next speaker we have is Professor Larry Chartrand, who you all know. He's been with Ottawa U since 1994, and I must say that he's the first full professor in a law school that's Métis, and that's a first for Canada. So that's really, really important. Congratulations, Larry. He's an accomplished scholar and an author, and he'll be speaking about the nature of Section 9124 and what the implications are for the Métis people. The third speaker we have is Professor Cathy Bell, who's a professor of law at the University of Alberta. She's also an accomplished legal scholar and author. She's the recipient of a SSHRC grant, the Social Sciences and Humanities Research Council grant with Professor Chartrand, and one of the reasons why we're all here today. She'll be speaking about inter-jurisdictional immunity and the implications for the Alberta Métis settlements. So we'll begin with Professor Magnet, if he wouldn't mind leading us off. Everybody will have 20 minutes to speak, and then we'll have 30 minutes for questions from all of you. So, thank you.
Thank you, Yvonne. I'm going to discuss the origins of the Daniels case, certain lesser-known aspects of it, and invite you to peer into some possible futures in its aftermath. In 1965, the Bilingualism and Biculturalism Commissioners noted that Canada was passing through the greatest crisis in its history, a crisis that was of existential import and had the potential to destroy the country. In the wake of that observation, Canada established special entities to study the constitutional ramifications and put on the ground an intensive effort to understand the special situation of the Aboriginal people, including the people Canada called Métis and non-status Indians, or MNSI. Cabinet memos and certain allied documents record the result of this effort. My litigation team fought and won many motions and a bitter trial battle with Canada to produce these documents and admit them into evidence in the Daniels case. After our motion victories, my team spent 4 years studying 150,000 pages of secret documents. And based on this evidence, we persuaded the trial judge that in 1980, Canada identified a core group of Métis and non-status Indians. Canada counted them precisely in 1995 at 198,000 Métis and 404,200 non-status Indians. Canada located their communities and produced detailed studies of their condition, including what it would take to extend services to them. The core group is a very small subset of Canadians with Native ancestry, which the larger group would number in the millions. The 600,000 people I've described are a very, very small, concentrated subgroup of that. The core group, Canada discovered, has distinct identities, are self-conscious of their histories as Aboriginal people, and can demonstrate their existence as unique forces in Canada's history. The judge was convinced at trial that Métis and non-status Indian circumstances were atrocious, that Métis and non-status Indians were the worst off of all Canadian citizens. And the judge was convinced of the reasons why. That although these 600,000 people had needs similar to the status Indians, federal programming directed to Indian needs excluded them. And so they were underdeveloped as peoples, even as contrasted with the status Indians. The secret documents show over and over how Métis and non-status Indians must cope with severe disadvantage and desperate circumstances, to use the language of a cabinet memo, and lived in conditions, in the language of another cabinet memo, that are intolerable, judged by the standards of Canadian society. A cabinet memo described these circumstances and Canada's policy of excluding Métis and non-status Indians from federal programming as arbitrary, anachronistic, and harsh. The judge found that Canada, like all governments, recognized that the causes and remedies of this underdevelopment had to be addressed at a national scale and not piecemeal province by province, that only national programming could be responsive to this critical national issue. Canada calculated the cost of extending Indian Act programming to these communities. And in court, Canada said this could be in the order of $4 billion a year. Canada engaged the provinces to seek provincial participation, reasoning that Métis and non-status Indians were provincial citizens like others, and the provinces were responsible to provide them with health care, education, social services appropriate to their needs. The provinces rejected this overture, arguing that Métis and non-status Indians were Indians within federal jurisdiction at Section 9124, that Canada was responsible for programming to them, and that Canada should reimburse the provinces for the cost of having provided education and health care services to these people in the past. So this began a dispute between Canada and the provinces about jurisdiction and responsibility for Métis and non-status Indian peoples. The secret documents record that the dispute between Canada and the provinces was bitter and emotional, that officials found it difficult even to speak with each other about practical solutions. The dispute has been going on for 2 generations. It remains a live jurisdictional issue today. After a 9-week trial in 2011, the judge found that the dispute damaged Métis and non-status Indians. It caused both federal and provincial governments to withhold services to these peoples that all governments recognized were necessary for their proper development. In other words, neither side was willing to blink in their dispute with the others, and the collaterally injured civilians of this dispute were the Métis and non-status Indians. In the language of a cabinet memo, while governments fought about jurisdiction, the losers are the Indians. Now, these are the findings that we were able to persuade the court in 2011 were the case. And these findings are consistent with what the Royal Commission reported in its studies in 1996. The Royal Commission said, and I'll read it to you, the refusal by the Government of Canada to treat Métis as full-fledged Aboriginal people covered by Section 9124 is the most basic form of current governmental discrimination. Until that discriminatory practice has been changed, no other remedial measures can be as effective as they should be. And the court's 2011 findings are also consistent with a secret cabinet memo from the 1970s, which said, I'll read it, the Métis and non-status Indian people, lacking even the protection of the Department of Indian Affairs, are far more exposed to discrimination and other social disabilities. In the absence of federal initiative in this field, they are the most disadvantaged of all Canadian citizens. The judge also found that resolving the 9124 issue had potential to clarify the roles and responsibilities of governments, offers gestures of respect and reconciliations to the peoples involved, the 600,000 peoples involved, and unblock what was a dysfunction in Canada's federal system. The government appealed. The Federal Court of Appeal upheld the judge's rulings, issuing a declaration that Métis and non-status Indians were within federal jurisdiction at 9124. The Court of Appeal upheld the Métis declaration, but vacated the non-status Indian declaration. At the last moment, Canada conceded that non-status Indians were Indians within Section 9124, without saying who they were or why. A little Johnny-come-lately concession. But the Court of Appeal used that to say, well, it's not necessary, therefore, to issue a declaration since you have a concession. But I believe, and argued before the Supreme Court earlier this month, this is erroneous. The concession is not binding. Canada remains free to continue its dispute with the province, especially about what it conceded. It ignores the judge's findings of damage, and the concession is not about the core group, but about those non-status Indians who have some ancestry, which nobody really thinks qualify for federal programming. It is just core groups of people with histories, identities, communities. All right, let me talk about now some lesser-known aspects of the Daniels case, which I'll address under the heading of the third declaration. My team also sought a declaration not just of jurisdiction and responsibility under Section 9124, but also that the federal government has the obligation to negotiate with Métis and non-status Indians through representatives of their choice, respecting their rights, interests, and needs as Aboriginal peoples. I'll just tell you briefly what this unprecedented request is based on. The Supreme Court's cases have made increasingly clear that Aboriginal treaty rights and claims must be identified, defined, negotiated, that Section 35 of the Constitution Act 1982 is the constitutional basis for this, and that the governing principles are reconciliation and the honor of the Crown. I won't bore you with the cases. The lawyers in the room will know that there's a line of basically 4 from Sparrow, Delgamuukw, Haida, and MMF. But I will tell you that in Manitoba Métis Federation, paragraph 69, the Supreme Court explained that the honor of the Crown is engaged by Section 35 of the Constitution Act. And the court said that it is a corollary of Section 35 that the Crown act honorably in defining the rights it guarantees, and that this is a constitutional principle. And the court has also said in 3 increasingly severe obiter that negotiations about this are a moral and legal requirement. Now, all of this case law is, Prime Minister Trudeau explained to the 1984 Aboriginal Constitutional Conference that this is what the Constitution makers intended for Section 35. I'll read you what Prime Minister Trudeau said. We started, he said, in 1982 by inserting in our Constitution Section 35, in which Aboriginal and treaty rights are recognized and affirmed. We were aware at the time that these rights needed to be identified and further defined in a constitutional process. We will find appropriate formulations for inclusion in the Constitution when they have emerged with some precision from our ongoing discussions. And in fact, the Constitution Act 1982 created just a procedure to do this. Section 37 required a First Ministers' Conference with Aboriginal leaders to identify and define the Aboriginal and treaty rights that Section 35 recognized and affirmed. That conference was held in 1983. Hard work. It failed. A constitutional amendment was proclaimed in 1983 requiring further conferences. 3 more conferences were held, 84, 85, 87. Hard work. These conferences also failed to identify and define the rights. Yeah, it's an interesting situation. The constitutional procedure created to define Section 35 rights proved inadequate to the task, and it's now spent. But, as the court pointed out in MMF, the obligation to identify and define these rights lives on as a constitutional principle which is enforceable. All right, so what's the result for Métis and non-status Indian peoples and the implications for the Daniels case? Well, looking at it from the point of view of Métis and non-status Indian peoples, when these peoples go out to exercise their rights to hunt, to harvest, to cut trees. They're arrested. Their trucks and their guns are seized, and they're prosecuted in criminal court. They can try their luck at making out a criminal defense. These prosecutions are going on all across our big country. Try their luck at making out a criminal defense. A criminal defense in these cases, I've done them, it requires, these are marginalized peoples, it requires huge resources. You have to compile an original historical record of the communities involved, going way back. So huge resources, historical records. There is a risk of equipment seizures. The equipment is important to these people, their trucks, their guns. And there's also a risk of jail, not because these people are criminals, but because they're Métis or Indians trying to exercise their rights. To say the least, this is not the path to reconciliation. The Supreme Court has said repeatedly that criminal trials are inappropriate means to identify, define, and implement Aboriginal rights. But what's the alternative? We say, my team says, there's only one. Negotiated agreements that identify, define, and implement the rights. Now, the record in the Daniels case shows that it's unlikely these negotiations will happen unless the court issues the third declaration, the obligation to negotiate with the representatives of the peoples concerned. The documents establish that Canada provides no forum where these negotiations can happen, has not engaged in them, and in fact is unwilling to engage with us. I pressed this aspect of the Daniels case forcefully in the Supreme Court of Canada earlier this month. There were 17 responding facta. Not one of them made an effort to rebut this aspect of the case, and I believe that's because it cannot be rebutted. I think if ever there was a case where the Supreme Court would be moved to act on its obiters that negotiations are a legal requirement, this is the case. All right, and I want to make clear that I am not arguing here for a duty like that you find in Haida Nation or Mikisew Cree to consult about potential rights violations because of some project, some resource development project. This is a different kind of negotiation altogether. This is an obligation to negotiate about implementing rights which are recognized and affirmed, but not identified, defined, or implemented. A completely different constitutional obligation. Let's just look very briefly at the future, or some possible futures. Daniels is likely to stimulate wide-ranging changes to Canada's core Aboriginal peoples' policies. And I believe that Métis and non-status Indian organizations would be well advised to consider making an effort now to garner political support for their visions of the aftermath, particularly with the new government. Daniels is ultimately about settling claims, implementing rights, unlocking human potential, and self-government for Métis and non-status Indian communities outside of Indian Act structures. I suggest that Métis and non-status Indian organizations now consider pressing the new government and the opposition leaderships for commitments on 4 fronts: on claims, that governments identify and document Métis and non-status Indian specific and comprehensive claims, working with the representatives of these communities. And in the wake of Daniels, the organizations would be well advised to negotiate with Canada a framework to resolve these claims within existing specific or comprehensive claims processes, or a newly created targeted process that is appropriate to the Métis and non-status Indian claims. And that these negotiations include the definition of a timetable for resolution of these claims. This business is unfinished and it must be finished. On rights, that the MNSI organizations established tables with Canada to identify, define, and implement Aboriginal and treaty rights of Métis and non-status Indian communities. I hope Canada will be ordered to do this. And that negotiation and of implementation of the rights happen on a timetable be negotiated. This is unfinished business. It must be finished. On human development, using existing Aboriginal Affairs programming as supplemented by the Kelowna Accord models to survey the programming needs of each of the Métis and non-status Indian communities, to establish tables with Canada to negotiate community-specific programming models and delivery methods acceptable to each community. And on self-government, to establish with Canada a commission to investigate models of self-government that could be applied to Métis and non-status Indian communities, to specify the processes that could be used to build up Métis and non-status Indian existing organizations to assume these responsibilities, and to begin the process of empowering Métis and non-status Indian NAOs, National Aboriginal Organizations, and PTOs, provincial territorial organizations, and their communities to evolve to assume these self-government roles. I believe that Daniels holds great promise for Métis and non-status Indian communities. I think it's very important for Canada also, not just because of the cost or potential cost, but also because of the possibility it offers to uplift large numbers of people who have been held back, and to help them and their communities develop their full potential as self-governing peoples. I'm very honored to have been entrusted with the lead role in the 16-year litigation effort, and I'm hopeful for a successful result. I believe that if you continue our efforts at the political level, a further stimulus will be given for needed changes to Aboriginal programming. These could usher in a new era in which the full potential of Métis and non-status Indian peoples is finally unlocked and realized, and that they take their rightful place as self-governing entities in Canadian society. Thank you.
Thank you, Professor Magnet. Now we have Professor Larry Chartrand.
Good morning, everyone. It's a pleasure to be on this panel and to speak to these issues that are raised in the Daniels case. I'm going to focus most of my attention to kind of a narrow issue, and one that actually wasn't directly addressed in the Daniels case. I know Professor Magnet has raised the argument about the importance of Section 35 as being the vehicle of an obligation on the Crown to negotiate the actual nature of the rights and that it's not a discretion of the Crown, and that Section 35 reinforces that obligation. I want to take a different focus and look at the fact that it's actually Section 9124 itself that has that obligation. So it reinforces Section 35 from that point of view. Now, I'm not going to spend much time on the issue of are the Métis Indians for the purposes of Section 9124, other than to say that the historical record, the empirical record, provides plenty of argument for the inclusion of Métis in Section 9124 to be understood as Indians, but not from a racial definitional point of view, but from a political, indigenous point of view. That Indians actually refers to polities that the British had an obligation to negotiate with, and that it makes sense from a colonial point of view that Métis be part of that broad definition of what it means to be Indian. And so I have no problem with that argument, and I think the historical record bears that out. And I think it also makes constitutional sense and increases the consistency within the Constitution itself to have Métis included within a broad definition of Indians in that respect. But the issue I really want to focus on is the issue of whether or not Section 9124, as a head of provincial power, is unique in the Constitution in terms of being a circumscribed power, unlike all the other heads of power in Section 91 and Section 92. Of course, I have an uphill battle in terms of making that argument because it doesn't coincide with the orthodox view of how the powers in Section 91 and 92 have been interpreted or understood to date. The prevailing view has always been that Section 9124, as a head of power over Indians and lands reserved for Indians, is plenary in nature. In other words, absolute. The federal government has absolute power to legislate over Indians and lands reserved for Indians. And that view has kind of emerged over time, but arguably it's not consistent with the original intent of Section 9124. There are compelling historical and contemporary reasons that this particular head of power never was intended and should not now be interpreted as a full plenary power like the other heads of power that deal primarily with things and concepts like taxes, currency, land, and property. Section 9124 deals uniquely with peoples, not things. In the courts that lead up to this decision in the Supreme Court of Canada, there's been the debate about, well, do we interpret this provision from a purposeful provision, or in a purposeful way, or in a progressive way? And the courts make a distinction between purposeful, and in this case I'm kind of equating that with the idea of originalism, that there was an actual intent at the time of drafting Section 9124 of what it should mean. And that's contrasted with the idea of progressive in the sense that the Constitution is a living tree, the interpretation of its provisions can evolve over time to account for change in social values, for example. I argue that a progressive, that the propositive interpretation, the original interpretation, provides compelling support for a qualified plenary power interpretation of Section 9124. And that also a progressive living tree approach that references contemporary Indigenous peoples' human rights and anti-racial discrimination discourses, also supports a qualified plenary power interpretation of this provision, without unduly stretching the written text of the provision itself, which was a caution raised in the Blais case. Indeed, in this case, a progressive approach is not incompatible with a propositive approach, as the progressive approach would bring us full circle back to the original intent of the Imperial Crown and the purpose of 9124 in the first place. It's basically the two sides of the same coin. So let's look at this originalism argument, this purposeful argument from the point of view of what was the original intent. We have a history of Imperial Crown policy. I have here a quote from 1763, instructions of King George III to James Murray, commander of His Majesty's forces in Quebec. He instructed James Murray to unite the nations of Indians with the British through treaty. Those were the words of King George III himself to Commander James Murray after the Royal Proclamation was issued. He goes on to say, in the fostering of good relations, King George III stated that the nations of Indians be induced by degrees not only to be good neighbors to our subjects, but likewise themselves to become good subjects to us. There's a lot said in that one statement. The first thing being said is King George did not regard the Indigenous peoples as subjects of the British until they were induced to become subjects, and that implies choice. Induce is defined in the dictionary to persuade, not to force. And this is the nature of British imperial policy leading up to 1867. And a lot of this imperial research comes from works like Charlotte Bell and Saugish Henderson and Bruce Clark. These are not necessarily original arguments. So we have an imperial policy of how to deal with the relations with Indigenous peoples. The imperial policy does not allow for unfettered intrusion into the affairs of Indigenous polities. Powers of colonial governments and their federal and provincial successors were circumscribed by imperial law according to well-recognized principles of subordination and delegation of imperial laws, Royal Proclamation being one of them, and have always remained paramount. In 1867, when the Imperial Parliament allocated jurisdiction to the federal government over Indians and lands reserved for Indians then, this power was necessarily circumscribed and qualified by imperial law regarding the obligation of mutual consent in defining Indigenous Crown relations. The division of powers in Section 91 and 92 of the Constitution are not exhaustive. They never have been. A decision called Campbell from the Supreme Court of British Columbia has affirmed that understanding of the nature of the Constitution. It was not until perhaps the Statute of Westminster in 1931 that Canada could enact laws contrary to British colonial law, a freedom that, however, did not apply to the British North American Act itself, which contains Section 9124. Not until 1982 was Canada able to amend its own constitution. And arguably, Section 35 now prevents Canada from amending Section 9124 to be an absolute plenary power. So that's the historical argument that I'm saying that argument is and creates a limit on Crown power built into Section 9124 itself. We also have to look at other arguments about the progressive interpretation of Section 9124. I mean, the United Nations Declaration itself, human rights instruments, simply are not compatible anymore with a unilateral absolute state power to legislate over Indians. Colonial imperial law originally recognized the primacy of Indigenous consent, spoken by the words of King George III himself. Principles of equality and human rights now demands the same respect for Indigenous consent. So what are the implications of this then? It means that, quite frankly, there are still outstanding obligations on the Crown to negotiate with Métis communities, as Professor Magnet mentioned, that ought to prevail and that ought to be reconciled with British Crown sovereignty. We need to resolve issues of land governance and resource sharing. This obligation, now said to be part of Section 35, has always been, in my argument, a part of British colonial law and logically informs the interpretation to be given to Section 9124. The colony of Canada was bound by this interpretation. And this is the implication of Section 9124 as a qualified and circumscribed power unique in that respect in light of the other heads of power. Now, we all know that there was no real debate about the meaning of Section 9124 during the constitutional debates leading up to 1867. It was relatively silent in the record. It's relatively silent in the record because there was no need for a debate. The imperial policy standed on its own at that point. And it's still the case today that it is a qualified power, as I mentioned, until Canada tries to amend it, although it would face Section 35 now of the Constitution. Now, it is, of course, the reality that this understanding hasn't been the dominant understanding of colonial governments. The Indian Act and its predecessor legislation was enacted by local colonies which arguably exceeded their authority when they enacted legislation without inducing the nations of Indians to agree to such interference in their affairs. And I say the same is also true of the Dominion Lands Act, legislation that purported to unilaterally extinguish the Indian title of the Métis outside of the postage stamp province of Manitoba. Now we know that there has been a lot of violation of this interpretation of the provision, Section 9124, by colonial governments, by the federal government, and supported by the courts in that regard. I mean, the courts in the late 1800s, early 1900s were very racist in arguing that it's a ludicrous idea to deny the application of the general law of Canada to Indigenous polities. There's no choice, there's no sovereignty, there's no self-government within those communities. The general law of Canada applies as like any other citizen, right? Of course, that understanding was built on the whole policy that developed from assimilation. The only problem with that is that policy was unconstitutional. So, what do we do about that? Well, we have an obligation to fight as Métis, right? Now, I'm going to accept that that I'm an Indian now. I think most likely that's what will happen in terms of the outcome of the Daniels case. I'm pretty convinced of that. What I do not accept, though, is that that government, the federal government, not one of our own making, can unilaterally legislate over me as a Métis Indian. That I will not accept. I'll never accept that. Such a state of affairs is contrary to fundamental principles of constitutionalism, negotiated federalism, and international human rights, and to our very nature of, as not very good Cree speaker, Otipemisiwak, the free ones, right? So as Canadian citizens, and especially as Métis citizens, we have an obligation and a duty to resist legislative attempts that ignore our political independence within the Canadian Federation. Such actions of resistance, I argue, are not inconsistent with the Canadian Constitution, but are fundamental to it. For in doing so, we are not trying to defeat the Constitution, but rather uphold it. Thank you.
Thank you, Professor Chartrand. We now have Professor Cathy Bell, who will be talking to us about Alberta Métis settlements.
Good morning. I'd like to start by saying thank you to Alex for all the hard work you've done getting us organized, and also to the many students who have been helping us over the last 2 days, making this a very, very comfortable environment. I know I think better when I'm well fed and I know where everything is, and so I want to thank the students who are here who have done that work for us. What I'm going to talk to you about today are some of the potential implications of the Daniels decision for the Alberta Métis settlements. Now, this forms part of a much larger research project that I'm doing for the Métis Treaties Project. And in particular, the question that I am interested in, there it is the extent to which the Manitoba Métis Federation case, and in particular, the duty that flows from that case to purposefully and diligently fulfill the promises, negotiated promises that are constitutionalized. Does that duty apply to the Alberta Métis Settlements Accord? And if so, what implications does it have for some of the contemporary issues that we are facing in Alberta with the Métis settlements trying to have their rights recognized, whether it ranges from a right to consultation, to a right to hunt, to issues around the constitutional vulnerability of the Métis legislation if, in fact, Métis fall within 9124. And I'm working with Dr. Kermoel on aspects of this project. So I'll go back here then to what I'm going to talk about today. The federal government has been arguing since this litigation was commenced in 1999 that there are no practical ramifications of Métis being included in Section 9124, that it's not going to address the evils that Joe brought out in his talk, and that in fact it does not give rise to any kind of a positive obligation to negotiate. In fact, what they have argued quite strongly until recently, along with some others, is that the only potential practical consequence might be that it makes provincial legislation dealing with Métis issues constitutionally vulnerable. So Daniels has many potential practical implications for the settlements. These are some of the issues I'm going to look at. For today's talk, I'm going to focus on the last two questions. So before and after Pauli, some provincial governments entered into agreements with Métis communities and organizations, typically in relation to initiatives to improve cultural, economic, or social well-being, or as frameworks for negotiation. The most comprehensive is in Alberta. The legislation and accompanying co-management agreement provide a framework for delegated local and regional self-government, collective ownership and protection of Métis settlement lands, creation of a unique landholding system and registry, and access to financial surface and subsurface resources. It is the result of a long history of negotiations dating back to 1938 and culminating in the Métis Settlements Accord in 1989. The legislation adopts several methods to protect the Métis land base and its viability for traditional and contemporary economic uses. The most significant protection is found in the Constitution of Alberta Amendment Act, which confirms the details of the Métis land grant in the Alberta Constitution. It also prohibits the province from revoking title to settlement land, from dissolving General Council, or from changing General Council's composition. It also provides in the Constitution that these protections cannot be amended or repealed unless a majority of members in each settlement votes in favor or until the Métis settlement's land base is protected in Canada's Constitution. As part of the Accord negotiations, a 21-year-old lawsuit against Alberta was also stayed on condition that the province does nothing to repeal or amend these provisions in our Constitution. Although the possibility of federal involvement and protection in the Canadian Constitution is written into Alberta's legislation, for a number of reasons this cooperation has yet to come. They include federal denial of jurisdiction over Métis as an Aboriginal people, and the refusal of both governments to acknowledge, negotiate, and implement Métis Aboriginal rights. For these reasons, Métis settlement legislation in Alberta and Saskatchewan's Métis Act are results-oriented and expressly state that they are not predicated on recognition or accommodation of Section 35 Aboriginal rights. Alberta and the Métis Settlements General Council nevertheless sought federal involvement in the amendment to the Constitution because it would make it more difficult for the province to amend or appeal its constitutional amendment, and because of the legal uncertainty of one provincial government to bind another provincial legislature into the future. However, the federal government continues to deny this request on the basis that the Métis and protection of settlement land are a wholly provincial matter. Since the Supreme Court of Canada recognition of Métis Aboriginal rights in Pauli, some provinces have also negotiated agreements and amended provincial laws to accommodate these rights. The geographical scope of these rights, the binding nature of accommodation agreements on future provincial governments without the involvement of the federal government in settling claims, and whether contemporary self-identifying Métis peoples, such as Alberta's Métis settlements, are entitled to exercise Section 35 rights, continue to be litigated in the province of Alberta. For these reasons and other reasons, Alberta has been arguing at all levels in Daniels that the Métis are not under Section 9124, but if they are, Alberta's legislation is a valid provincially run ameliorative program. It also argues that the Supreme Court of Canada should not even rule on the vulnerability of this issue because, among other reasons, it is unnecessary to resolve the question of whether Métis are under Section 9124. The Métis Settlement General Council and Gift Lake Métis Settlement were also interveners in the case all the way up to the Supreme Court. Both agree the matter of constitutional vulnerability should not be addressed, but they disagree and they argue that Métis are within 9124. General Counsel further argues that the Métis hold the primary right and responsibility to define who they are, and where such definitions exist and have been negotiated, they should be respected. Gift Lake intervened on different issues, including how Métis history in northern Alberta and the reasons for the creation of the Métis settlements provide an important context for understanding Métis inclusion in Section 9124. Saskatchewan argues provincial Métis laws are valid as long as they relate to a provincial head of power and that the doctrine of interjurisdictional immunity is eroding. The doctrine of interjurisdictional immunity is a constitutional law concept that suggests some core matters under Section 9124 are immune from invasion by provincial governments. I agree that this doctrine is eroding, but I think it is still unclear to what degree. The case law that is relied upon by Saskatchewan speaks to provincial laws of general application that are not directed at an Aboriginal people or their Aboriginal rights. And as I will discuss shortly, the Alberta Métis settlements could be distinguished on this basis. However, I also argue it's irrelevant because I think that Manitoba Métis Federation and the principles of honor apply to the Métis settlements and call on both the federal and the provincial governments to do what is necessary to implement the promises in the Accord. The Federal Crown argument rests on an interpretation of Section 9124 by the Supreme Court of Canada in Dilgamuk. The argument is that Aboriginal peoples and their rights are immune from provincial laws because matters of status, Aboriginal rights, and title are within core exclusive federal jurisdiction. Dale Gibson argues the proper way to understand this idea of core jurisdiction in relation to Métis is a concept of Métis-ness, that which is central to Métis identity and may or may not be distinct or distinctive from other Aboriginal peoples. Under a strict application of this doctrine of interjurisdictional immunity, the only way a province can pass a law that impairs core areas within 9124 is if it is a law that is a general law that is not directed at an Aboriginal people or its rights, or secondly, that provincial power finds a source in another place, such as Section 88 of the Indian Act or the Natural Resource Transfer Agreements. These sources of provincial regulatory power do not include the Métis, meaning that laws that are directed at or that in some way impair Métis-ness may very well be outside of provincial jurisdiction. However, there are several arguments against this position that the provinces cannot legislate with respect to the Métis, even if they are 9124. One of them relates to what we call the dual aspect of the legislation. Alberta argues that the Métis settlement regime falls within provincial jurisdiction because it deals with matters of property and local government common to all of the citizens of Alberta, such as elections, transmission of interests of property, and resource rights. Further, it is not in its purpose or its intent directed at Métis Aboriginal rights. However, a closer examination of the legislation reveals extensive powers of self-government and control over land and resources that are not enjoyed by other citizens in Alberta or municipalities, and control over aspects of Métis life and culture that are very analogous to a contemporary modern land claim or modern treaty. It's this dual aspect, of federal and provincial features that many will argue will uphold the Métis settlement legislation regardless of whether they fall under 9124. Further, following, and this is what was accepted by the Federal Court of Appeal in Daniels, this dual aspect argument. They said regardless of whether Métis are under 9124, the settlements are saved by this dual aspect argument. The legislation is saved by this dual aspect. Following the Federal Court of Appeal decisions, the Supreme Court of Canada also released two more decisions concerning the division of federal and provincial powers that call for a restrained approach in this application of interjurisdictional immunity, particularly in the context of Aboriginal and treaty rights. For example, assessing the potential application of the BC Forest Act to Aboriginal title in Chilcotin, the court held that the doctrine of interjurisdictional immunity has no role whatsoever to play when we are looking at the question of Aboriginal title lands. Rather, the court held that the proper framework is Section 35, which calls for consent or to meet the justification process. This reasoning potentially extends more broadly to all established and credibly asserted Section 35 rights, as the Supreme Court of Canada has not distinguished between federal and provincial law in determining duties of consultation, accommodation, negotiation, or justification flowing from Crown actions. The same reasoning, therefore, will also apply by analogy to the Métis if they fall within Section 9124. However, Chilcotin is concerned with a law of general application, the BC Forest Act. The question still remains whether interjurisdictional immunity continues to preclude a province from passing laws that are directed at an Aboriginal people, such as the Métis Settlements Act. However, I would argue that the reasoning in Chilcotin and subsequent cases like Grassy Narrows and other cases on interjurisdictional immunity suggests that the constitutionality of Alberta's Métis legislation is not going to turn on whether it is characterized as a law of general application. Rather, the issue is going to be whether it relates to a valid head of power, whether it significantly impairs federal power, or whether it infringes Aboriginal rights. This is the argument of Saskatchewan and the Métis Settlements General Council before the Supreme Court of Canada. Another argument that was accepted by Justice Phelan at trial is that this provincial law is fine because it is ameliorative, that it addresses an issue of disadvantage. And it relies on Cunningham and Lovelace, this argument. It relies on Cunningham and Lovelace. Although both of these decisions uphold provincial laws and programs alleged to violate Section 15 rights on the basis that they are ameliorative, they do not suggest in any way that an ameliorative purpose alone is sufficient to justify invasion of Core 9124 jurisdiction and the federal fiduciary relationship between Aboriginal peoples and the Crown. At issue in Cunningham was whether provisions in the Métis Settlement Act prohibiting status Indians from being Métis settlement members and termination of membership on this basis violated charter arguments of equality, freedom of association, and liberty. In dismissing the Section 15 claim, the Supreme Court of Canada held that the Métis settlements regime is a special type of ameliorative program, one designed to enhance and preserve the identity, culture, and self-governance of a constitutionally recognized group, the Métis. Cunningham, Daniels, and the Manitoba Métis Federation case speak to what Alberta has been ameliorating since the 1930s, the collapse of the scrip system that left Métis people landless and destitute. It is, however, possible that certain sections of the Métis settlements legislation may be vulnerable. And this is coming up currently in litigation before the Alberta courts. What's happening is, as a consequence of Cunningham, many settlement members are being forced to leave the settlements. These members signed up for Bill C-31 status, not knowing it would affect their Métis settlement membership, and they cannot get off the Federal Indian Registry. Once you are on, you cannot get off. So the issue of jurisdiction is going to come up again. Gift Lake is challenging the application of Cunningham, and their argument is that these provisions with respect to status and determining if you are a Métis person or a Bill C-31 person may very well violate core jurisdiction if Métis or 9124. It's a complicated argument that I don't have time to go into. What I would like to conclude with is what some of this might mean in terms of contemporary intergovernmental relationships between the federal government, the provincial government, and Alberta Métis settlements. I think there are two significant ones, and Joe has spoken to the first one. That is, read with other Aboriginal rights jurisprudence, Daniel suggests that both governments have the duty to enter into good faith negotiations with Métis regarding infringement or impact of their rights, as well as their Section 35 rights. What I want to speak a little bit about in conclusion in my last 5 minutes here is that read together with MMF, Daniels also suggests both governments have an obligation to ensure the necessary steps are taken to fulfill the purpose of the Métis Accord, regardless of the outcome in the Daniels case. Here I draw on some work that I've been doing with Paul Seaman, who is a Métis lawyer at Gowlings, one of the counsel for Gift Lake and Daniels, and we've been doing some work on Métis consultation. In Manitoba Métis Federation case, the Supreme Court of Canada held that Canada failed to deliver on the promise it made to the Manitoba Métis to provide them with land due to delay, inappropriate methods of allotment, and exposure to land speculation. Because of this failure, the Métis were soon displaced by settlers and some forced to move further west. In 1881, Métis located at Fort Edmonton petitioned Canada for scrip owed to them under the Manitoba Act. The names on the petition are comprised of many Métis whose descendants are now Métis settlement members. Others are descendants of Métis living in Alberta at the time the settlements were formed, who took or were entitled to take scrip under federal legislation in the 1880s that was connected to implementing the Manitoba Act scrip promise, as well as people who were scrip recipients through the treaty scrip distribution process. These Métis joined together with non-status people to petition Alberta for assistance because Canada denied responsibility after land and resource rights were transferred to Alberta. In 1934, the Alberta legislature established the Ewing Commission to inquire into the problems of health, education, relief, and general welfare of the half-breed population of Alberta. The Métis Population Act was enacted as a result of this commission, and the commission called for negotiations with Métis political representatives to implement its recommendations for the creation of Métis farm colonies. Through this negotiation process, some Métis settlements were created in areas where there was a substantial historical Métis presence. However, other important considerations were taken when selecting the lands, such as access to agricultural and lands and timber for erecting homes. Following a period of delegation of governance and after a process of extensive litigation and negotiation, the Alberta Federation of Métis Settlements and the province entered the Métis Settlement Accord. In the Manitoba Métis Federation case, the Supreme Court of Canada held such obligations grounded in Crown promises aimed at reconciliation attract the honor of the Crown were owed to an Aboriginal group, but they need not necessarily depend on proof of a pre-existing Section 35 Aboriginal right or title grounding the promise. Aboriginal interests is a broader term, and like the land grant promised to the Métis in the Manitoba Act, the Alberta Métis Settlement Land Grant is negotiated and a solemn promise aimed at reconciliation protected by Alberta's Constitution. As such, and I'll close here, the Manitoba Métis Federation suggests that both Crowns, the federal government through its failure to implement the promise of the Manitoba Act and its subsequent legislative framework for addressing Métis land interests, and the provincial Crown through the Métis Settlement Accord are required to act with diligence to fulfill the purpose and the promise of this negotiated regime, if indeed it is threatened by 9124. Thank you.
Thank you, Professor Bell. We have the floor open for questions, and we have a mic on either side of the aisle. So, this side.
Okay, thank you for... Hello, let's work. Okay. Thank you for the... Merci pour les excellentes présentations. Ce matin, j'ai eu un peu l'impression d'être aux Nations Unies. Donc, j'ai une question et deux étonnements. First, I am very surprised to don't heard about duty to consult and fiduciary obligation. That was at the core of the Daniel judgment and the MMF judgment. Second, I don't heard about what I call the betrayal of the MNC in the appel of Daniels. They put out the Indian, non-state Indian. I don't heard about this too. The other question, the question is to Professor excuse me, Magnette. Professor Magnette, how, in your point of view, see the ideal resolution of the Daniels affair in the Supreme Court with some direct and indirect implication? Thank you.
I think it was just because of the time limits that we weren't able to get into some of the issues that are being raised by the Métis Nation. But my final slide here does raise some of the broader issues that we didn't have a chance to talk about, and that are questions around race-based approaches to definition and whether the distinctiveness of the Métis does in fact exclude them from being within the definition of Indians. I don't think that that is the case, but that is what the MNC that is one of the things that the MNC has been talking about, but they don't think it excludes from 9124 as well. It just means that Métis are distinctive within that definition of Indians.
Mr. Magnet?
Yeah, thank you for the question. The ideal outcome of the Daniels case, of course, is to agree with me. And I think that if the court does that, that the sequelae will be Canada resisted this case fiercely. We haven't really seen that. I, as a private lawyer, would be unable to use litigation tactics that Canada put various junior lawyers through and was criticized by the court. Canada's concerned about the sequelae, but I think I understand the concerns, but principally cost, and that there is really not a political constituency for those expenditures, so that it's governmental effort that attracts, depreciation of the vote. This is the problem. I take a longer-term view of it, which is that the current Aboriginal programming of approximately $11 billion on a $200 billion plus federal gross general expenditure, or 5% of all federal expenditure on Aboriginal programming, has produced some wonderful success stories in empowering and uplifting and developing Aboriginal peoples. But everybody in this room is very well aware that along with this, there are some outrageous failures, and that many, many, many Aboriginal people live in conditions that are very hard to justify in a rich, capable, resourceful country like this. And so that programming has been very, very difficult to unbundle and retarget and stuff. Daniels offers the possibility of just that kind of an impact with the programming. In other words, another population about the same size of the status Indian population now has claims on that programming, but they do not live on reserves. And so most of that $11 billion is targeted to reserve infrastructure, band governance, etc. So there is the opportunity now to take a fresh look at the urban Aboriginal communities, at the Métis communities in rural and remote places, and ask the hard questions for which there are, in this room, a lot of very interesting and thoughtful proposals out there. What is the right kind of programming to uplift, to develop, to empower these people to become self-governing, and to release all that talent? That's, to me, the ideal outcome. So Daniels would be a first step to unblock what's become a frozen situation of the programming, to require retargeting of it, and in the process to stimulate a rethink and a redevelopment as to how best to empower and uplift these people.
Okay, we'll go to mic 2 over here.
Oh, sorry. Yeah, go ahead. Ani Bojo, my name is Kara Kennedy. I'm a third-year common law student here at U Ottawa. I'm from Uquamakong. I just had a question open to the entire panel. I was just wondering specifically, what is the maybe you've mentioned this, maybe I didn't get the point, but what is the specific relationship between Section 9124 and Section 35? And if it's only plenary in nature, is that like, and at its most practical level, is that like the relationship? And my other question is, Professor Magnet, in your pleadings, you mentioned that, I don't know if I was getting it, but you said that the interpretation of the Constitution was both progressive and propulsive, but I was wondering what the difference between, what are the specific differences between like purposiveness and originalism, and whether you think that a purposive or progressive interpretation advances the issue of Métis rights and being included in Section 9124. Sorry, that's a lot.
We could do like a whole class on that. Do you want me to do the 9124?
Yeah.
I mean, the relationship between Section 9124 and Section 35 is really part of what is being explored in the Daniels litigation. Section 35 is directed at specific rights of Aboriginal groups and peoples. Peoples, I would say, actually, is what it says in Section 35, pardon me, not groups, but is being interpreted by the Supreme Court to apply to groups. The purpose of Section 35 is arguably different from the purpose of 9124, which Larry spoke to in his presentation. And one of the things they're trying to sort out in Daniels is whether and how those sections are read, and if they are read together. Fair enough.
Yeah, that's a great question. Thank you for it. My colleague, Larry Chartrand, was speaking about progressive and purposive, and maybe he would like to develop those thoughts if you're willing.
Yeah, that's a good question. I mean, that has been a debate, actually, in terms of the Supreme Court of Canada's jurisprudence and in the interpretation of the Constitution. What is the appropriate methodology in terms of how we should interpret? And so there's this distinction between purposive, what is the purpose behind it, what is the meaning behind it, and that is often thought of in terms of what was the original intent behind the provision in the first place, and that's why it's often sometimes equated with originalism, but it's not necessarily the case. And you compare that to progressive, which means, well, we have to recognize that the Constitution was enacted in 1867. Lots of things have changed. Our values, our beliefs have changed over time. The Constitution needs to change along with those values. And so if you can read a provision in the Constitution that is consistent with contemporary values, then the court will try to do that. I mean, one of the more famous cases, of course, is the Persons case, where women were ultimately included within the definition of person, when the original intent was said that women weren't persons for the purposes of Senate appointments, etc. So those are the two distinctions. My argument is that it doesn't matter when it comes to the interpretation of Section 9124, whether you take the original approach method or the progressive method, you're going to get to the same place. You can't enact legislation over Indigenous peoples without consent, right? That's what the words of King George III instructed Canadian officials in terms of imperial policy, which I believe was the way the section was supposed to be interpreted.
Thank you. We'll move over to mic 1. Paul?
Thank you. I was very interested in the panel discussions, presentations, and I can say that I'm delighted to see how the Daniels case has progressed to this point. I have fond recollections of participating in the original drafting of the pleadings with my late friend Harry Daniels in Edmonton a long time ago, it seems. I can assure you that we enjoyed the process and we enjoyed a good bottle of Burgundy wine after we had finished the job. But I was happy to see that subsequent to that, the task was taken up by very able, competent people, and I look forward to the decision of the court. I have one question, which I think is a fundamental one. It engages the Court of Reconciliation because it involves the concepts of consent and legitimacy in constitutionalism in Canada. Both Joe Magnet and Larry Chartrand talked about an obligation on the part of the state to negotiate. My basic question is, negotiate with whom? We know that the discussion of negotiation of a legitimate constitution based on the consent of the people has a fairly long and extended history now in the Canadian courts. Most of you will know about the Quebec secession reference case. And I refer there to the proposition that consent is a foundation of constitutional legitimacy, as the courts have said, since at least the 1985 Manitoba language reference case. That being so, it can be argued in regards to the question I'm proposing, negotiate with whom, that just as there is an obligation on Canada to negotiate with a province when, by democratic means, the population of the province demands negotiation on the terms of the Constitution under which the province is prepared to live. I say, just as a province is a relevant constitutional unit, so is an Aboriginal people. I've outlined that argument in an article in Waikato Law Review. Now, if we proceed from there, we find there an ingredient that is missing in the context of the situation in which you're both proposing negotiations. It is this. In the Quebec secession reference model, to seek consent and therefore establish legitimacy, the duty is triggered by a process, a political process, whereby there is a democratic demand, I will call it. The democratic demand required that there be, by democratic means, the creation of a common will to negotiate. Now, I won't go into the details of that, but I'll go directly to the question here. And I will give an example and put a very specific question to the panel. What the democratic demand element in the Quebec secession reference model contains is it ensures the political legitimacy of the negotiating parties and the capacity, the political capacity of the negotiating party to negotiate on the basis of legitimate support, political support that it has through a referendum. Where is that in your models for proposing negotiations? And I will finish by asking a direct question by using an example. In the MMF case, the current Liberal government, through the Trudeau platform, proposed that it would negotiate with the Manitoba Métis Federation Incorporated a reaction to, as you know, it's not legally binding, but it's only a declaration, but nevertheless, the government has agreed to negotiate with the MMF something to deal with the declaration in MMF that the government didn't do the right thing. And I'm fairly familiar with the right thing. I wrote a book about it in the 1980s. But the question here is this, that in the MMF case, there were quite a number of parties. There was the MMF body corporate, and there were several individuals. Now, those individuals that were not participants in the actual litigation process, they did not get a chance to instruct counsel. Is it just, is it fair, or on what basis would you say that it would be right to negotiate only with one of the parties to the MMF litigation? So my specific question is, what would be your advice to the Trudeau government about entering into negotiations with the MMF pursuant to the MMF case?
Yeah. Well, thank you, Paul. Paul Chartrand and I have been friends for more than 20 years, I think, so perhaps he will allow me to correct some of the inaccurate information that he provided, having to do with a good bottle of wine with Harry Daniels. I don't think it was a good bottle of wine that you and Harry shared. I think it possibly was in the plural. Possibly some cases, having known you both for many years. And now let me come on to your question. Negotiate with whom? Advice to the MMF, some individual plaintiffs in addition to the corporate plaintiff, the MMF. Of course, there are individual plaintiffs in Daniels as well. Daniels is set up as a national case. The plaintiff is the Congress of Aboriginal Peoples. Harry Daniels was an original individual plaintiff. After his death, he was succeeded by his son Gabriel Daniels, a Western Métis, a Central Canadian non-status Indian, Leah Gardner, and a non-status Indian from the Maritime Provinces, Terry Jodrey. Negotiate with whom is a very interesting question, but it's not a difficult one. In other words, what occurred in the 1980s is that Canada had engaged with the representatives of the Aboriginal people, with the national Aboriginal organizations. CAP then included the Métis organizations, and there was a split, and separate NAOs were formed. Canada continued to negotiate with those NAOs, and in the early 1980s, it broke down saying, it became very interesting, saying, you know, we're here, and those negotiations were done through formal structures. There was a federal cabinet committee that was created to carry on those negotiations with the Congress of Aboriginal Peoples. And it met 5 times, the Federal Cabinet Committee and CAP. And you may remember that when only 2 ministers came, there was a sit-in and a protest and all that sort of stuff. Very interesting. And there was also a federal minister for this process to facilitate these negotiations, the federal interlocutor for Métis and non-status Indians. You know, in the 1980s, these said, you know, we'd like to help you with your problems, but we can't. You're not within our jurisdiction, and therefore this problem that the Daniels case was meant to unlock. Negotiate with whom? Well, those are the entities with whom Canada negotiated. They have legitimacy, etc. Now, in the Aboriginal constitutional process in the 1980s, the First Minister's Aboriginal leaders meetings, this question came up. Canada was supposed to invite the representatives of the Aboriginal peoples to the conference. And so it invited the NAOs that it was aware of, but some other groups, the Prairie Treaty Nations Alliance, Native Women's Association, so we're legitimate representatives. So there's the question. Invite us. All right, there was discussion, some negotiation about who should be invited. People couldn't agree, and so there was litigation in Prairie Treaty Nations Alliance in Canada and NWAC and Canada as to whether or not they should be invited. I frankly don't even remember how it came, but it's not a difficult question. You get it up, the case is made, there's a decision, and that's it. I appreciate there are very refined questions in there as to what kind of evidence, who can come and who can intervene and who's a party, but all of that is a question that can be and was resolved so that the negotiations can go on. The last part of your question is advice to the MMF. Advice
to the Liberal government.
To the Liberal government. With the MMF case, obviously, you have to invite the MMF, and then you have to see who, as in Prairie Treaty Nations Alliance and the NWAC cases, raise their head and make a case to be invited, and the sources of legitimacy, and to try to work it out. And if it doesn't work out, again, it's a litigible question, not particularly difficult, and a court can deal with it. So that would be my advice, which is invite the MMF and other interested parties, put out a general call to see who they are and what their case is, try to resolve it, expect litigation, and then get on with it.
So is it fair to exclude the other parties?
Pardon? They'll have to identify. They'll have to identify themselves. You know, Canada will put out the general call.
Let me interject there for a second as well. I think, Paul, you actually answered that question yourself in a book chapter you wrote, edited by Professor Mallet and Wilson. And you argued the position that in terms of identifying the Métis community that has the political status to negotiate with other peoples, including the British Crown and Canada that represents it, it's up to the Métis people themselves to define through internal processes who are the members of that community. And it really has nothing to do with Canadian law, nothing to do with other people's law. It has to do with Métis law, Métis politics. And there are Métis processes for our communities to decide under what circumstances is your community or are individuals part of the people. What are the values and principles that inform that decision-making process, and to apply them. Now, of course, we have the complication of Métis peoples deciding to circumvent our own laws and processes and policies, and that's a different issue altogether.
Okay,
sorry, can I'd just like to add one more thing, and that is, I think it depends on what you're negotiating. If you are negotiating the content of Section 35, that's a different question than if you're negotiating based on fulfillment of a promise and an honor-infused promise. And I say that because I think there is a room for Métis Settlements General Council at the table on specific issues that relate specifically to them.
Thank you. Okay, we have 3 more speakers, and we're over our time. So if we could just have quick questions, we'll do mic 2.
Thanks, Jenny Dubois, Université Ottawa. It was a really interesting panel, and I thought it was interesting that Professor Magnet, in your opening remarks, it raised some political questions that I think, Professor Bell, you answered in your presentation. And I'm a political scientist, so I might not be getting some of the legal things a little bit confused, but I wanted to ask a question about that third declaration that you were talking about, Professor Magnet, and what could be accomplished politically and legally with it. Because as you mentioned in the MMF case, it was clear that the honor of the Crown is engaged by Section 35, and the political response to that so far has been, for example, the naming of the special rapporteur to provide a potential framework for potentially negotiating a legal framework for Section 35. And I'm wondering what the declaration in the context of this, such a declaration in the context of this particular case could bring about differently legally, but also politically, especially keeping in mind the opening remarks of the Crown at the Supreme Court about open federalism as sort of the framing of that, which goes to Professor Bell's comment about, well, how much of it is provincial and federal jurisdiction, and providing space for them to have different policy frameworks within which to function. So I'm just wondering how the politics and the legal interact in that, and what that third declaration could provide for that.
Well, put yourself in the position of advising the government on this. In other words, you would look to the Justice Department and you'd say, wow, here is a declaration ordering us to negotiate with the representatives of the Aboriginal people concerning their rights, interests, needs as Aboriginal people. What do we really have to do? Right. So if you're giving advice on that, you would be saying, right, this is a first. We haven't seen this before. I think that we should, make diligent efforts to be engaging these people. We don't want to get too aggressive. Let's assume that it's the old ways. We don't want to get too aggressive here. What do we really have to do? I think the answer would be you run a risk that, number one, people will see you as illegitimate if you don't follow through on what the Supreme Court has ordered. You don't want to get yourself into the position of the Harper government of going to war with the Supreme Court. So you're running a big risk, but you're the politicians, you figure it out. You also run a risk that if you don't do this in good faith, more coercive orders could be made against you to do this, that, and the other, and there would be a cost to that of losing control and having the court assert increasing direction over what is meant to happen. So those are the parameters. Now, I realize that in attempting to answer your very good question, that I've left a sort of fluid environment there. But let's be honest with each other. The environment is fluid, and the third declaration is meant to insert a force into that fluidity that drives a current towards unfreezing what is now a frozen situation.
Thank you. Mic 1, Tony Belcourt.
Thank you. Fascinating panel. And Larry, you may want to consider having a conference on this subject alone. Lots of questions about, I'll just ask my one. Prime Minister-elect Trudeau has said that he's going to implement the United Nations Declaration on the Rights of Indigenous Peoples. Will this somehow render Section 9124 moot to some degree, since the recognition of the right of self-determination means that Indigenous peoples have power to govern themselves and therefore are their own level of power? And sub-question, how do you implement the UN Declaration?
Very good question, Tony. I mean, there's some countries actually have domesticated the declaration into their law. The Philippines, for one, has pretty much word for word enacted the declaration as their domestic legislation. So that's one obvious option. That could be legislated. In terms of the implication of the United Nations Declaration with respect to whether Section 9124 would remain relevant, I think that might be the source in terms of. Well, I'd have to think this carefully, because you don't want to argue for imposition of legislation which counters the very rights in the Declaration in the first place. I think it would have to be a negotiated process. I've always, based on some of the research I've done, I believe 9124 was always intended to be the basis or the power to which a negotiated understanding could emerge. And I don't think, I think that would still remain with the idea of the declaration being implemented. But I don't think we can just take a liberal, approach to saying we know what's best for you, we'll implement the United Nations Declaration on your behalf. I personally agree that most of the principles in it are very, very strong and go far beyond the Aboriginal rights doctrine we currently have. But I think it's going to have to involve a negotiation process, which I think 9124 and the prerogative of the Crown's authority is the source from the government's point of view.
So this sounds shocking to me coming out of my mouth, but the government of Alberta is currently reviewing all of its policy with Aboriginal peoples based on the United Nations Declaration. When Rachel Notley was elected as Premier, she issued a directive to every department in the Alberta government to review their relations with Aboriginal peoples based on the United Nations Declaration and to enter into negotiations with the First Nations and the Metis on a results base to try and understand what that means. So I just offer that as well.
Very good. Okay, our final question on mic 1, please.
My name is Janine Stingle, and I work for the Métis and Non-Status Indian Relations Directorate of Aboriginal Affairs in Northern Development, Canada. I'd like to offer some comments, not in my capacity as an ANSI employee, but as a card-carrying member of the Native Alliance of Quebec, a regional affiliate of CAP. That out of the way, I'd like to offer some thoughts to all three, and whether you would like to respond to them or not. I had the honor of being in the actual courtroom on October 8th to see Professor Magnet argue before the Supreme Court of Canada. And by all accounts, if you get 3 questions from the panel in your hour-long submission, you've done pretty well. And it did appear as though the court was very receptive to the arguments. My thoughts are that the law on fiduciary duty is pretty well set. Not sure you'll get that second declaration, but if you get the first and the third, you're laughing. Not sure about the whole idea, sir, Mr. Chartrand. Not sure about how much the court's going to get into the propulsive versus progressive, although there were lots of questions about it. It'll be interesting to see if they address that in any way. Positively gobsmacked that the court actually asked CAP counsel, Mr. Magnet, if we grant the first declaration but not the second and third, does that make the first declaration hollow? Mm-hmm. Gives a very, very insightful sense of the court's preliminary thinking. Professor Bell, again, I'm not sure. If anything, there could be a less focus on the vulnerability of provincial legislation, and it might be even looked to, the Alberta Métis settlements legislation could be looked to as a model, as part of that reconciliation. I do think the whole Peavine, Gift Lake, you know, we're poised at the brink of a positive finding, and then we're going to have a bunch of Section 15 spin-off litigation. Mm-hmm. And I think that's where Peavine may come back to haunt the Supreme Court, mm-hmm. but we'll see what happens with Gift Lake. Yeah. I hope the young people here remember this session, because this will not be the last of these arguments and what we hear. And what an honor to have been at the Supreme Court to see you argue that. It was very, very impressive. Yeah, I think that's pretty much it, and just a reiteration that I'm here in my personal capacity. Oh, I'm sorry, my last comment was to the moderator. Are these presentations available to the conference attendees?
Yes, they will be. Right, Larry?
I have to ask everyone to make sure that they're okay with it, but it will be posted on the Métis Treaty's website, those that agreed to
Thank you.
For me to do that.
And Professor Magnet, Professor Bell? Thank you. Okay.
Thank you for those keen observations. So should we give a big hand to our panel? Thank you very much.